Many of the complaints point to a 1898 Supreme Court case, United States versus Wong as proof that the 14th Amendment enshrines birthright citizenship. However, a quick look at the syllabus shows something very different. A child born in the United States to parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes, at the time of his birth, a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. To start, while Wong Kim-ark's parents were of Chinese descent at the time of his birth, they were permanent residents of the United States, even though they were subjects of the Emperor of China. Hold on to that thought for a moment. The fact that issue was when Wong Kim-ark returned from a temporary trip to China, he was refused entry. But why was he refused entry? Reading from the syllabus, because the said Wong Kim-ark has been at all times by reason of his race, language, color, and dress a Chinese person and now is, and for some time last past has been, a laborer by occupation. It's interesting that the reason Wong Kim-ark was denied entry into the United States was because of his looks, not his place of birth. Now, the court came to an interesting decision. The court ordered Wong Kim-ark to be discharged upon the ground that he was a citizen of the United States. But since Wong Kim-ark's parents were subjects of the Emperor of China at the time of his birth, he was not subject to the jurisdiction of the United States and therefore not eligible to be a natural-born citizen. What the court found was that because his parents had permanent resident status, they were subject to the jurisdiction of the United States, and that qualified him for citizenship. Was that following the law or the Constitution?